Hello, are you in a situation where you're going through a divorce or about to file for divorce and you're wondering whether or not you can get the other party removed from the marital residence while the divorce is pending? And my answer to you is, well, yes, but also it depends. Hi, my name is attorney Anthony Spratley. I am the owner and founder of Genus Law Group in Albuquerque, New Mexico, where we practice law and we do it with integrity. Now, at the beginning of a divorce, usually a party will file a motion for exclusive use. And when that happens, the court has to make a determination of whether or not one person will live in that home or whether or not both parties will continue living in that home. And there are many factors that the court looks at. One of them is, does either party have the financial means to remain in the home or to move elsewhere? And also about the safety and the health and welfare of both residents, to make sure that, one, they can live peaceably together, and also if a party moves out, that they can also continue to support themselves. And also I've seen situations where maybe the person that is being asked to move runs their business out of their marital residence. And so the court will consider who should remain in the marital residence because of a factor like they're running a major business out of their business, and relocating would be a big deal. But ultimately, the court wants to make sure that the parties are safe and that bills continue to get paid related to the home, the mortgage gets paid, the rent gets paid. And so the court will grant a motion for exclusive use of the marital residence if it makes sense. Also, the court's goal is not to kick someone out of the house and then they're homeless, right? Because if the parties can live somewhere peaceably together without incidents of domestic violence or abuse, it's likely that the court will say, you know what, I'm not going to kick out the other party if the other party doesn't want to leave the residence. So oftentimes, we get someone who will be concerned about receiving a motion, and they'll say, well, what does this mean for my rights? Do I lose rights to my home if I move out, voluntarily or by court order? And my answer is an emphatic no, right? You don't lose your rights to the marital residence or ownership or any community assets or property or tangible property in that home because you move out. You're just as entitled as a person that's remaining in the home in accordance with the law. And so if you are asked to leave the marital residence, make sure you do a good job of taking an inventory, pictures, videos, etc. Get witnesses to make sure you know what's in the house at the time that you leave, so that your community property, your interests are protected. Okay, so again, if you want to ask the court to remove someone from the home while your divorce is pending, it's possible. You have to file it. You have to file a motion, but that doesn't necessarily guarantee that the court will grant it, and you may have to still continue living with that other party while the marriage is pending. All right. If you know anyone that would benefit from this video, please share it with them. If you're in a place that you can subscribe or please do that as well. If you want more content, obviously you need to subscribe, but you can also go to our website at www.genuslawgrp.com, or if you want to talk about topics like this or other topics, you can reach us at 505-317-4455. Okay, till next time, take care.